Yeah, this question is being raised, especially when people file it concurrently. Most of the employers ask directly to pay the attorney or whatever the whole fees. I believe 485, 765, and all can be paid by employee, right? So,
well, the attorney can accept the fee because that could be reimbursed again, right? The employer could reimburse the fee to the employee. So that there is no
okay,
issue with the attorney accepting that fee. That is there's an arrangement between the employer and employee for that. Now the attorney is not allowed to accept a perm fee. That's by regulation. In I-140 situation, the attorney has no, I mean, will have to, of course, give proper advice as to who should pay and for what reason. But there's nothing to stop them from accepting the fee because that could be reimbursed, and oftentimes it is, by the employer to the employee, because in the interest of, like for example, during this October bulletin season, there was not much time, and a lot had to be done. So it was difficult to get checks from different places. So it's possible that attorneys might have accepted fees from the beneficiaries, and the beneficiaries were after that reimbursed. So yeah, that is a different situation, and I don't see any issue with that. But I think that no matter what the situation, that reimbursement, it's better for the employer if that happens, because then it's questionable as to whether an actual job offer existed or they were just doing this, they were selling the green card, So the look of it is also very important. It shouldn't look improper and then start and be a cause for some kind of an audit. So that's very important to keep in mind.
got it. So, but 485 and 765, I believe it's completely fine, right?
Yeah, that is a 485. So, and anything to do with the 485 is completely, it's a beneficiary driven petition. The employer really has nothing to do with, except for the 485J, which they have to sign. They have nothing to do with the 485. That's signed completely by the applicant.
Sounds good. For the viewers, if you want to reach the Attorney Prashanthi for a private consultation, please reach at 212-354-1010 or prashanthi@reddyesq.com. Again, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use this information at your own risk. Yeah, Prashanthi, going back to the I-140 thing, what happens when the I-140 is denied? Do they have to do all the process again? Or, could you please shed some light on how it works?
Right. So now we have filed the I-140 and perhaps, most probably maybe an RFE was received, and that RFE could be with reference to ability to pay, or it could be that, the degree date. Remember, we talked about the date of the degree. It could be because of that, or it could be it's not that the university was not accredited. There could be so many reasons why an I-140 gets an RFE and then is ultimately denied. The new reason is now they're asking for right to control, employer-employee relationship in the I-140 also. They're asking for to show that there's a valid job offer. So they're asking for contracts, agreements, to show that that business is good and that there is the likelihood that this is a valid job offer. So it could be denied for that reason as well. If you don't submit proper documents, it could be denied upon RFE for ability to pay also. So there are many reasons why there could be a denial. But once you get a denial, then there are two things you could do. You could appeal, which may not be useful because an appeal is very rarely overturned. Or you could refile the I-140 if you're able, depending on why it was denied. For example, if they deny it based on the fact that you don't have your bachelor's degree was completed much later because you got the degree later, and so you don't have 5 years of post-baccalaureate experience and you don't qualify for EB2, and you filed under EB2, and that was the only reason for denial, then you can refile using the same labor another I-140, and this time you ask for EB3. So it's the same labor, same requirements. You're asking for EB3 so that you don't have that bachelor's plus 5 years post-baccalaureate experience issue, right? So you could refile it. Maybe the case was denied because you were not able to show ability to pay for the current year because the tax returns were not yet filed. And the P&L statements were not audited. You were not able to submit audited P&L statements. You could refile because maybe by the time you refile, the tax returns have been filed, and so you can refile with those tax returns. But there's some instances in which you cannot refile because the perm itself is the problem. So there's some requirements in the perm that you have put that the beneficiary is not able to show. For example, maybe you put XYZ skills in the perm, but the beneficiary was not able to get an experience letter. Or you put a bachelor's requirement in the perm and the beneficiary does not have a bachelor's from an accredited institution. Then you cannot refile the I-140. Then you'll have to refile the perm itself. And then this time not ask for a bachelor's degree, but ask for just experience and redo the perm under EB3. So it really depends on the circumstances, whether the issue is, whether that evidence or the reason for denial can be rectified by simply refiling the I-140. Now we have to remember also that when you're refiling the I-140, you're filing it with a duplicate approval. So, and it's also most probably beyond the 180 days. Now a labor cert is valid only for 180 days. You cannot file an I-140 after that. But in the case of a denial and refiling, the 180 days doesn't apply. So, you're good with reference to that. You can just refile and show clearly in the refiling that you're submitting it with a copy. You have to put it in the cover letter in bold. Otherwise, they'll return the I-140. That you're submitting it with a copy and you don't require Department of Labor to submit a duplicate because the USCIS already has the original with them. So these are some things to keep in mind when you refile.
Okay,